Good afternoon. My name is Camille Crary. I am the Director of Legal Services and Public Policy at the Ohio Alliance to End Sexual Violence. Today, we are very grateful for your time and attention on this really important issue. We have been working on Title IX regulation processing essentially for the past several years. And so we've followed and practiced within the Title IX realm since 2016. So now we are on our third set of standards from the government. On that, when we first started taking these cases, we were under the 2011 Dear Colleague Letter guidance. And then after that, we were under the interim guidance proposed by the Trump administration, and on May 6th, the final regulation that had gone through the notice and comment period was released. And so we have spent time with you all 2 prior Mondays doing an overview, a substantial overview with a half an hour of questions each day. And today we'll focus on a few outstanding issues that we didn't get to. And then we'll have some slides on the advocate perspective, and then we will do a longer form Q&A. So I just want to go over a couple of technical points. We have the question box. So the question box you'll see is in the bottom portion, and we will look at those throughout. But generally, when we do these webinars, we do the questions at the end of our content. And we do that just to make sure that everyone can get the consistent data and information and formulate questions, because we may cover an answer to that question at some point in the later slides. So I just want to reintroduce everyone. We have Kendra Roberts, who is the LAV attorney from the Ohio Survivor Legal Assistance Clinic, and April Carter, who works closely with her at the Ohio Survivor Legal Assistance Clinic, and then Becca Getson and Chelsea Daniel, who are OAESV's wonderful legal and campus advocates. So we have a team that has a lot of different expertise areas and backgrounds, with a lot of time spent on college campuses and K-12 institutions kind of across our expertise areas. So we do want to acknowledge, though, that with the murder of George Floyd and the unrest that is happening across the country, we want everyone to feel very comfortable taking whatever time they need. This will be available as a recording, and we are also extremely happy to do a follow-up TA, a one-on-one training, anything that you need. So if you need to rest, please feel free to do that. Take a step back, come back to it when it's a better time. So with that, I am going to hand it over to Kendra, but I will remain on the line for questions.
Thanks, Camille. Hi, everyone. Thank you for joining us today. My plan today is not to talk at you for too long. We'll review some things, and then we're going to get into some more practical advice, like Camille said. And as you just heard, we will open up the majority of our session then for questions and answers. And so we may not keep you here until 3 o'clock, but we will be available for the question and answer portion as long as that takes. So let's get things underway. Okay, so before, like I said, we kind of went through step by step all of the language and the new rules and what this may mean for us as supporters of survivors. We talked about what we probably can expect, but some of these holes where we see that each school may interpret the new rules pretty differently. And again, what that's going to mean not only for survivors, but for us as we try to guide survivors through this new process. I'm going to go over the significant changes today, not nearly all of them, but the things we need to keep at the forefront of our brains as we think about how to handle this in reality. And then we want to hear from you what questions you might still have, keeping in mind, of course, that some questions are going to be unanswered and unanswerable until we see exactly how these new rules are implemented. And so a lot of the answers we have to these things are extremely hypothetical at this point. But we can, you know, give our best reason given our conversations that we have had with other administrators and with, you know, how we have seen the progress of these new rules come to fruition. So let's keep in mind above all that there's these central themes throughout the rules. And the reason I go back to this each time is I think that when we are left with wondering what a school may or may not do in a situation, or vice versa is not the right term there, or working with a survivor after a school has made a decision that we don't understand or agree with, and we're looking for a somewhat of a why, I think we have to go back to remember what the language in the new rules really stresses, and that's free speech and bias. So there's a central focus on free speech. We see it everywhere, from the more stringent definition of harassment to the more stringent definition of retaliation as you know, during or following the Title IX process. The bias, again, we see a lot of kind of attempts throughout the process to either stop or check for any bias. But again, the language in the rules kind of seems to insinuate that the bias we're trying to avoid here is gender bias. That is, the gender of the respondent shouldn't have a bearing on the decision maker, and you know, in regard to whether or not they are responsible for sexual misconduct. And again, glaringly, we don't see other types of bias listed here that we would perhaps hope to. That doesn't mean that we don't have the right to and shouldn't be looking out for those types of bias. And because there is this, you know, opportunity to call out bias when we see it, even though the rules spell out gender, I think we as supporters of survivors have to watch out for various types of oppression that result in bias and call that out as well. We see this shift from punishment to process. That is, the new rules give institutions some pretty detailed do's and don'ts throughout their grievance process, and we see this delaying of any real repercussions for sexual misconduct until after there is a finding of responsibility. And until then, the parties are treated both as just really parties. And I, as I've been working through a lot of these sort of conversations with different people involved in the Title IX processes in different places, I really think that one of the ways we can kind of ground this for ourselves and for survivors as we explain this going forward is maybe we're not calling the parties perpetrators and victims, or even complainant and respondents early on, in the event that that's going to confuse a survivor, because it's clear that the school's intent in this process is for them both to just be parties until the end. The survivor, of course, knows they are an abuser, they are a perpetrator, they are a guilty party, but I think that if we refer to them as both as parties as much as we can, it may push you know, that underlying maybe unfortunate reality that we're probably not going to see remedies or realities that survivors may want until the very end of the process, when that responding party becomes a responsible party. And then also, let's keep in mind throughout that the Title IX coordinator really holds a lot of power in this, and they're going to be the gatekeeper, they're going to be your check. So we need to make sure we not only know who that person is, but that we have a direct line of contact with them throughout the process. All right, so let's just go review what's new. Remember that the bar, in order for something to be named sexual harassment and therefore to be a possible violation of sexual misconduct and subject to Title IX, So to even begin this process, to even make a report that that you were subjected to or someone was subjected to sexual harassment, now we're going to have to show that both that conduct was severe and pervasive and objectionably reasonable to offensive to a reasonable person in order to rise to the level of harassment. Again, already off the top, we see this free speech for college kids, right? So in the workplace, showing either of those things would be enough to show sexual harassment, but at college, because kids will be kids, we're seeing that we need to be able to show all of this. Again, it's not as if when a complainant sits down to write a report that they need to draw out, this was severe to me because, and pervasive because, but we just need to know this as how it is being interpreted first by the institution and then thereafter by OCR and ultimately by the courts. In order for it to be sexual harassment that the school has a responsibility to address, that needs to occur within education programs and activities. It seems to be an attempt to really limit that area of control that the schools have. It obviously remains to be seen how this is interpreted, but the language is pretty restrictive. It's substantial control over the context, whatever that means, of the harassment and the person committing the harassment, and that it occurred in a building owned by the school or an officially recognized organization of the school. Let's keep an eye out for how those are interpreted by the schools, because that may be a place where we really need to advocate for survivors when something occurs technically off campus. Also, we have this new reporting versus complaint process, and the initial step is this reporting of a violation. Let's remember that anyone can make that report, third party or not, and they can do it by any means. The school has to allow them to make it by email, by telegraph, by online portal, by paper, in person. Any means is okay to make this initial report. What the school has to do in response is reach out to that person who has been subject to the harassment or to the violence, and they have to promptly, so quickly and reasonably respond to them. As I think I said before, probably any real reach out, hey, you need to talk, let's try to talk at this time, from the coordinator is going to be sufficient to meet that burden there. At this point, when the report is made, remember that the survivor already has these rights to supportive measures, even if they don't go any farther. Therefore, we have to remember for survivors that may be unsure on whether or not or how they want to proceed, that they can simply report and ask for support, and then they do not have to go further unless they so choose. The respondent should not be receiving notice of this report in most instances, so that is something too that we need to keep an eye on and make sure schools are not doing that. Advocate for them not to do that if we see them doing so at this stage. Of course, keeping in mind that in a really severe case, the school's going to maintain that discretion to notifying the respondent in the sense that they could immediately remove the respondent from campus. Then we have this new formal complaint arena, where this is the actual document. So this is a specific official document, and this is what launches the investigation, not the report. So we need to make sure we're finding what that official document looks like. It probably is going to look a little bit different at each institution, and we're going to make sure that there is a document that's signed by the complainant, because if the school either forgets or just doesn't really take this step seriously, then arguably that leaves open the respondent's ability to say none of this that occurred matters, or the sanctions don't hold up because you never even initiated the proper formal complaint process. Obviously, in the K-12 context, it doesn't necessarily have to be signed by the student. Probably in most cases, there will be a place for the student to sign and for the parent or guardian to sign if they're under 18. This again is the point that triggers the rest of the investigation and any hearing or other events that will follow. And at this point, the respondent not only is going to receive notice, but they're going to receive support. Again, at this point, they're both just quote unquote parties. So we need to warn survivors that this is where we're going to see some things that seem not only unfair, but probably hurtful in many cases, because the respondent is going to receive the same opportunity for support that the complainant already received when they made that report. Okay, also keep in mind that there's this opportunity for schools to dismiss these complaints. So even though a survivor decides to file a report and then they decide to take it to the next step and sign this document initiating the formal complaint, that does not necessarily mean that there will be an investigation. The school still has a way out of investigating, and that is this. The school has to dismiss that complaint. That means throw it away, say no, there will be no more process. They will not investigate if either it does not describe sexual harassment, right? So that earlier definition that we looked at, those terms are not all met, or that they can say it didn't occur in the school's education programs or activities or in the United States. Again, this remains to be seen how schools interpret their programs and activities, but this may be a way that they avoid taking up a matter. And then they still can do so and probably will do so. It'll be presumed that they will dismiss in these cases. So when the complainant wants to, which is probably a good thing for our survivors, if they don't want to go through with the process, it's unlikely that the school is going to require them to. If the respondent is no longer a student, or if whatever these specific circumstances that prevent the school from gathering evidence exists are, again, it remains to be seen how often that will be used by a school and what that will look like, and factual scenarios that will lead to that. But it is an option for the schools. And then remember, now we have this new area of appeal. This is this first stop appeal where the decision to dismiss a complaint or arguably not to dismiss the complaint can be appealed. Remember too that there's an option of informal resolution. This only becomes an option after that initial formal complaint document is signed. Both parties have to agree to it, but it can be made available to both parties in any case, no matter how severe the sexual misconduct. Again, this is going to put a stop to the formal process, no matter where it is at that point in the investigation, or maybe the investigation's already completed and we're looking forward to the hearing. Unless the school has specific language against it, it appears that both parties could still volunteer to instead enter into this informal resolution. And in this case, the goal then being that both parties, after some sort of process that we don't really know what it'll look like yet, but ultimately will sign some sort of agreement with terms that they both agree to. Either party can end this process before that agreement is signed. So it can be the day that this agreement is supposed to be signed after months of, a back and forth. They still have the right to stop it and go back to wherever they were in the formal process. Again, after that agreement is signed, that closes the case, so they can't then also have an investigation on the same facts. We know that the school is going to provide an unbiased facilitator to oversee the process, but we don't necessarily know what that facilitator position is going to look like or what the process is going to look like. This is really kind of a blank space for schools to come up with. And so we're not going to have a lot of planning with a survivor here or notice to give a survivor here. We can tell them that it's probably some sort of agreement, of where and when parties can be certain places, perhaps an acceptance of responsibility of some kind. But again, as far as what that will actually look like, we're going to have to see how each school interprets that. Will it be a kind of civil negotiation process? Will it look kind of like mediation, dispute resolution? We will see. Keep in mind that the school may be changing the standard of proof that you're used to. You may be used to a preponderance of evidence standard. That's the 51%. That's the more likely than not. They may change to using a clear and convincing evidence standard. That's somewhere beyond probably, but less than beyond a reasonable doubt. So somewhere probably between 51% and 95 to 98%. The school can change it, can use whichever they want. It's up to them. They just have to say ahead of time which one they're going to use, and they have to use the same standard in all sexual cases. That does not mean they have to use the same ones in other types of cases, other disciplinary cases that are not sexual misconduct cases. They can use whatever standard they so please, as long as all respondents in sex cases are the same standard. So employees and students will be subjected to the same standard. They can't use an increased standard for students and a lower for employees anymore. All right, also what's new, I'm not going to go through each of the procedures, but just know that we know that the rules have put out some really specific procedures throughout the investigation, some rules for investigations, and then also through the hearings and appeals. And the big things to remember in the hearings is that the parties are going to have this right to an advisor who may or may not be an attorney. They're going to get to choose who their advisor is. Advisors must conduct the cross-examination in a hearing. So the parties have right to cross-examine the other party in the hearing, and if that's going, and witnesses, and if that's going to occur, then that cross-examination, that question answering asking session has to be done by advisors, not by parties. So if a party does not have an advisor, the school will give them one. That person will only be there to do this cross-examination portion that we talked about. There's no training required here. And so OAESV is going to adamantly state that this person conducting this cross-examination, even though the rules leave open the possibility that this person is basically anyone, OAESV is strongly stating that this person needs to be an attorney at law. Attorneys are the only profession who are trained whatsoever in cross-examination techniques. No other person, including advocates, are or should be expected to be, and there remains a residual large looming question of whether or not doing so not only subjects that party to a deprivation of their rights, but also subjects that person conducting that cross-examination process without being an attorney to allegations of practicing unlicensed practice of law, or some other ethical considerations that ultimately culminate in not only the very likely potential of harm to the survivor, but also to the person in that advisor position. So that if there's cross-examination in a hearing, that needs to be completed by an attorney, and advocates need to be trying to link survivors with attorneys as soon as possible, anticipating that this is a possibility. We also knew under the new rules that if a party or a witness fails to appear, the decision maker, so what we're used to is typically a panel, is not going to be allowed to consider their statements. This has been true at most places with witnesses already, given some case law that came down. It remains to be seen if this is true about a respondent, and the harm being, if this is true, and a respondent who has the right not to testify against themselves. But if they don't either appear or they don't answer cross-examination questions, does that mean all of their previous statements cannot be considered? Because if so, that's a little problematic, I think. And also, does this increase the likelihood that a witness will be intimidated into not appearing? We know that the decision makers will give a written decision, and that written decision is going to be pretty lengthy because it's got to include several things. It is at this point, after the finding of responsibility, that the complainant can ask for and can receive remedies. These remedies are supportive measures, but that can be punitive, so can somehow punish, can somehow burden the respondent and not the complainant. However, it is still required that these remedies can be shown to somehow protect the complainant, either their physical safety or their right to education. And so in that written decision, not only does the respondent get to know exactly which remedies were given to the complainant, but the school's going to have to explain themselves and why they chose to give those remedies. And so arguably, we would assume that that would be subject to appeal, as would anything else in the written decision by the respondent. In the investigation, we know that you know, this emphasis on equality, again, they're both just parties during this time. That means they're both going to get time to the same opportunities to look at the same items or to speak to the same investigators, whether or not they take those opportunities. There may be a lengthier investigation process because we know that the parties have to be given a reasonable time, number one, to review anything, any evidence or statements provided by witnesses or the other party, and to respond to that. We know that the parties have the right to inspect and review, but not necessarily the right to copies of relevant evidence, and that relevancy point is going to be determined by the school, not by the parties. So arguably, we may see instances where we want to see something submitted by the other party, but the school says, no, it wasn't relevant, so you don't get to look at it. We're going to see investigation reports. And this process in and of itself is going to take a little bit longer. There will be a preliminary report, but both parties get 10 days to respond to that. And then once that final, and those responses must be considered by the investigator before they write the final report. And the final report, after the final report, there has to be at least 10 days before there's a hearing. Appeals, we know that there's these three means of appeal. These are probably pretty familiar. We've probably seen at least one or more of these before. Schools can give more, but probably will not. They probably will all just give these three grounds, though again, it's going to be up to the schools to interpret what these really mean. Both parties can appeal on these grounds. Both of them get one chance to respond. Because the rules draw that out, I think it may be unlikely that we see many schools giving this. Sometimes we see schools giving a double opportunity, right? A second appeal. That may not be the case any longer because the rules don't spell that out. And again, as we look to retaliation, it's going to be unlikely, I think, that respondents' words or words of third parties alone are going to be deemed retaliation because we see this focus on free. Okay, so before we get into some more practice points on a step-by-step basis, our advocate team is going to talk a little bit about some things that as advocates working with survivors in this new arena that we need to think of as we receive these cases and as we go forward.
Great, thanks Kendra. So the next couple slides, we wanted to spend a little bit of time talking about advocates, particularly when working with survivors in a Title IX context. So first thing first, right, for us. And one of the things that Chelsea and I have talked a little bit about is how easy it is to kind of get wrapped up into this, right? The Title IX regulations that come out, what's going on, what are the things that are changing, what's going right. And for advocates, the survivor still comes first, right? That is still our priority. That is still the first thing that needs to happen and consider, right? So that's kind of the first thing that we want to make sure kind of re-highlight for folks. And with that, schools have different priorities than that, right? So they have to consider survivors and respondents and all parties involved and what that looks like and being a neutral person, right? So they have to take all that in consideration. So when working with a campus or K-12 institution, creating a team is something we cannot emphasize enough, right? Kelsey actually even does a better job of talking about this than I do. But one of the things we want to make sure and really highlight is to create that team, right? That attorney advisor, the campus-based advocate, community-based advocate, that all those people kind of come together to create a team. and that is done in such a way that is supportive to survivors, that is the best way to kind of approach that case. And that could be a whole variety of different other people, right? The parent could be involved, the legal guardian could be involved, the other support friends or family, right? But what is that core team and what does that look like? And really keeping in mind that although the advisor doesn't have to be an attorney, one of the main things that advocates can't do is provide advice, right? So those are very distinct and different roles. So a good possibility for advocating within the system and to universities and K through 12 and campuses is that those are two different things, right? A support person or an advocate and an attorney or an advisor are two very different and distinct roles because the advocates are there for that support piece, right? And although attorneys can do that support as well, they can provide that advice, right? And advocates have the ability to provide more holistic support and focus beyond that particular incident, right? So as we have everyone together here, I did want to make sure and highlight that there's very different purposes for that. There's very different reasons to have both a support person in the form of an advocate and also an attorney as an advisor as well. Next, in terms of thinking through what to do and how to use the Title IX regulations is that safety planning piece, right? And for both institutions and advocates, it's important to think through safety planning, right? So one of the things that the regulations talks about is removing people, respondents, if there's any kind of physical threat, right? So making sure and asking those questions, right? And unfortunately, sometimes survivors will minimize, right? They won't want to ruin someone's life oftentimes. So trying to get that information from them about what is helpful, and that can be a really great benefit to that, right? What is that looking like? What does that mean for the survivor? And then utilizing those resources on and off campus, right? Also, campuses change on a regular basis, right? So institutions have school breaks, they've got field trips, they've got buses, they have on and off campus events, they have international events, right? So all these kind of different things, making sure that the institution and the advocate and the advisor are all on the same page in terms of what the safety planning looks like. And advocates have been heavily trained in this, right? And how to safety plan, what this looks like, what that means. So it's really important for the advocates to be able to continue that safety planning and also know what that looks like. It is very possible to do safety planning without burdening another party. So schools have the requirement to not burden the other party during any kind of safety measures or support measures until they find that other person responsible, right? So until the respondent is found responsible, there can't be this undue burden. All that being said, though, it's still very possible to do safety planning. It's really important to utilize those support measures that can be done even before formal complaint is initiated. And that's something very clearly laid out in the regulations that can still be done, that the support measures, and something that Kendra mentioned, is those are still available, right? Also making sure you've got privacy and confidentiality considerations. Are there MOUs between institutions and advocacy agencies? Are there MOUs between police officers and police agencies, prosecutors, institutions, right? What does that look like? What is that relationship? And are you having those conversations before a survivor even gets involved, right? Are you having collaboration meetings or monthly committee meetings or bi-weekly committee meetings, whatever that looks like, right? To make sure you're talking about these issues before they happen. In that same vein too, these things are going to be taking a while to put together, right? So making sure to look at that on an ongoing basis, right? So before the semester starts, once the semester is ongoing, over winter break and summer breaks, all those kind of different things. And then once again, make sure and you remember the K through 12 and the campus differences, right? Everyone's gonna have different perspectives on this. There are different rights involved here. There are different laws involved for both K through 12 and for higher education institutions. So really considering those differences and who has to report what, right? So if a survivor is at a higher education institution, they'll probably be able to share their story a little bit more widely without any kind of report being made. At a K through 12 institution, if any employee knows about it, they're going to be reporting it. So if a survivor is, 14, 15, 16 and don't want to report to the school, they're going to be really limited in terms of who they can talk to, right? So just being really aware of what those kind of limitations are and what those privacy and confidentiality is. The last thing I want to really make sure I highlight, and I know that you all have heard this from me, I think I've become a broken record on this, but make sure you know you're on campus. And that's referring to both the K through 12 and the higher education institutions, right? I also want to make sure and highlight these regulations have not been out long, right? I feel like all I've done for the past year at this point is talk about Title IX. These regulations have been out a month, right? Not even that, right? So making sure that everyone's aware of what kind of time frame it looks like. You might be reaching out to your institution asking questions, and they may not know yet, right? They may not have the policies, and survivors are going to be frustrated with that sometimes, right? Not knowing what they're going to be looking at, what they're going to be running into, what the policies are going to be, and that just takes time, right? So trying to be as transparent as possible, and also looking and having advocates be content experts, and advocates reaching out to institutions, right? Talking about trauma and what that means, but knowing who those folks are on campus, right? Meeting them and understanding who they are, what their roles are in advance can really help work through when reports and formal complaints come in, right? So this timeline coordinator, student conduct, principals, all those kind of things, right? Who are those individuals? Who are the trainers? I would also highly encourage advocates and institutions to use advocates and local folks to do training, right? And even if it's not training on the policies, because if that has to be internal, or if you had to get someone else to do that, they can train on trauma and what sexual violence is and how it can impact and those kind of pieces. Who does student life? What's that housing and dining and transportation? All those kind of different things, right? All those are going to be impacted, which means over the next several months, institutions are going to be working to make sure everyone is aware of what this looks like, which also might mean it's going to take some time, right? And there's going to still be a lot of unknowns before that August 14th deadline, where the rules actually come into place, unless there's something else that stops those rules. So just kind of a couple of highlights. I know we're leaving a lot of today for Q&A, but I do want to kind of throw in a couple of those considerations just to kind of think through both how advocates can kind of continue to use the regulations, but also how institutions can utilize advocates and those content experts in their areas. So thank you, Kendra, and I'm going to turn that back over to you.
So I'm gonna give just a few more points, real practical points and things to keep again in our mind as we proceed here. Some of them will be very repetitive to what Becca said, but I think it's really important to stress these things as we try to grapple with what our job is going to look like next year and even after that. First, I don't recommend to anyone that they read 2,000 pages of federal regulation. In fact, I might adamantly say don't. But I think it is worthwhile to look over the rules and the other resources at that Department of Education site, because I think more than anything, the way that you as supporters of survivors will become familiar with what the maybe intent or what the themes, what the language is trying to convey in the new rules is by kind of just look it over, familiarize with yourself with some of the words chosen and the language used. I think that's a really great starting point. And then as Becca alluded to, right now is a really kind of golden opportunity, I think, to speak for survivors in ways that we don't always get. The school officials are doing exactly what we're doing. They're sitting on webinars trying to debate on what this means and then what it means that they do and don't have to do and what they need to write in their policies or what they need to get rid of. So if we do have relationships with certain campuses, now is the time to use those and reach out directly to Title IX offices or other administrators that you know. Offer to help, offer to, like she said, give expertise. You know what survivor needs, you know how Those policies may be more trauma informed, and you know what has worked and what hasn't in the past through this process. So you can be a little annoying aunt, I think, right now, because we have to also know that it's probable that groups with other interests and probably diverging interests are not afraid to do this. So we need to try to get in there and be an ally to the school officials as they wrestle with this. Again, you need to review the specific policies. Every single policy is going to change in the upcoming year because it's got to incorporate these new regulations. And so the words may be similar, but they're not going to be universal. So read them closely before, probably before you ever get a survivor that has a Title IX case. That way you know what to expect a little bit. And then you've had the opportunity to ask questions. If some of those policies look like, well, there's no way to even know what that means, or there's some information, some really important information missing from this point, you can ask the school. They may not even realize that they kind of left those unanswered questions. And again, you can help kind of frame filling in those blanks the best way for survivors. Key point to look at is the standard of proof, not only which one the school chooses to use, but is there any language in the policies about how they will apply that standard of proof? And probably a lot of that is going to be trial and error, and that we're going to have to wait and see. So if they do change their standard of proof, we're going to have to see kind of how it goes in actual cases. And so we're going to need to keep that in mind. That way we can inform survivors going forward. Okay, I think this one's really, really, really central. And it seems obvious, but I have to remind myself of this every day in this work. We can't make any assumptions. So we're going to read the regulations and we're going to assume, well, that means they have to do this. That means they cannot do that. We need to really avoid those absolutes. The schools still have a lot of space to interpret these new rules and to use their discretion. That is, to make their own choices and how they put them into place. So while we are going to read these things and believe these words should mean something or should mean that a certain action is taken, that may well not be reality. And we need to give this warning to survivors, especially now with these new regulations. Survivors are not dumb, so they're going to read these policies and they're going to make their own inferences. And they're going to be, as you all know, quite disappointed when the reality is different than what they expected. So we need to warn them up front that, because of this interpretation, because of this discretion, what we think should happen will not happen in every case, will not happen in every step of the way. May happen sometimes, but absolutely will not always be the result. I need to link the survivor with the attorney immediately. I know I sound like a broken record and I'm begging for cases, I think. That is not the case. I'm sure I'm going to have plenty of survivors to work with and plenty of work even outside of that trying to wrestle with the implementation of these regulations. But for all the reasons we've already mentioned, the sooner the better. When we get a survivor, we need to immediately be talking with them about the benefit of getting an attorney and helping them seek that free legal advice. If at all possible, that attorney should be talking to the survivor even before that report or complaint is filed, because the rule of thumb is that the attorney should be a sounding board for that survivor, should be able to advise that survivor, that client, before they give any words to anyone else. So before they release any information out into the the world, they should have those confidential and protected conversations with counsel. They need counsel. Counsel is not a substitute for a advocate. We, in fact, as a profession, and advocates probably know this better than anyone, attorneys are not in practice advocates and are not real skilled in advocacy skills always in the ways that survivors need. So a survivor needs both an advocate and counsel. The new rules, particularly important right now because of like the things we've said, these rules are new, everyone's interpreting them. Whatever happens now will become the precedent, right? It will set the standard. It will be, this is how we do it. And so it's going to be really important that attorneys are involved in that to try to protect survivors' rights through that settling of the dust. And then again, we've already talked about this, but again, cross-examination is a practice to be undertaken only by attorneys, licensed attorneys, and so survivors have the right to have someone skilled in that practice. All right, let's look at the decision to report. Again, as Becca and I have both kind of already alluded to, if you have a survivor who just isn't ready to make the decision about what to do totally, but they do know that they need some support from the school, they can report and only seek support. We need to warn survivors up front that the meeting of harassment may be a little bit more difficult now, and it's probably true that words alone, either online or in person, are going to be unlikely to meet the elements of a violation or the elements of a charge of retaliation. That's not saying never. I'm just saying that this is, so during these conversations with survivors, we need to really be digging deeper and see what else is going on to try to meet that standard. Again, this goes along with don't make assumptions. We're preparing the survivor for reality. We have to let them know up front that the respondent is going to receive rights. In fact, the respondent is going to be treated just like they have been until after the hearing. I'm sure that you all have worked with survivors who are very aggravated and very even traumatized, I think, by the way a respondent is handled throughout the process. And I think that's going to be even more true under the new regulations. And so we need to set the survivor up for that ahead of time so that's not a shock. They should expect process over fairness. Again, assumptions about what should or shouldn't happen because they were assaulted will not supersede the processes that the school puts in place or that the regulations put in place. This is a period of unanswered questions. All of these regulations are new to everyone involved at every level, and so we need to be upfront with survivors about that. Not only may you or their attorney not have answers for them that they would expect you to, but we may not know what's going to happen until after it happens, because it may be the first time the school has dealt with this, and unfortunately they are in this kind of experimentation phase of the new regulations, and so they may not have the benefit of notice that other students have had before or will have in the future, but we need to be upfront with them about that. Warn them about this new dismissal procedure. There's a chance that even after they sign that paper saying let's investigate, it may not happen. Warn them about the duration of the process. While the school has to be prompt under the new regulations, it may end up being longer than others have been in the past, because it says more chance. It's actually more chance to review and respond. So, both parties get this chance to not only review and consider, but also to respond to anything submitted during the investigation. Keep in mind that at the beginning, when the respondent receives notice of the allegations, they get a time to review them before they actually are interviewed by the office. And then we know that, during the hearing, there's this cross-examination process, the hearings last longer, and there is this appeal process that we know that involves some additional requirements and more time. We need to survive that. We need to survive them. We need to provide survivors with the warning about relevancy. There's a lot of talk throughout the new regulations that, relevant evidence will be considered, and during the cross-examination questions in the hearing, the decision makers will determine if each individual question is relevant before the other party can answer it after it's asked. We need to, again, remind the survivors here that relevant is not some sort of objective term. The decision about each individual item and whether or not it's relevant, each individual question and whether or not it's relevant, is not made by us. It is made by the school, so either by the coordinator or the decision maker in the hearing. Because there is this emphasis on bias throughout the rules, we're going to see respondents making lots of claims, probably from the very beginning through the very end, about bias. They're going to claim that the coordinator is biased. They're going to claim that the decision makers are biased. They might claim the advisors are biased. They're going to claim that any sort of interpretation is biased because of their gender. All of that is not to say they're going to succeed on those things, but it is to say that it can be intimidating for survivors when respondents are, quote unquote, filing all of these complaints about bias one after the other, in these big stacks of paper. And so we need to warn survivors that we expect them to do that, and that doesn't necessarily mean that they're going to succeed in that way. When we're discussing the decision with the survivor on whether or not or how to file that formal complaint after they've made the initial report, we need to make sure we are getting an official document from the school. The school may slip up and not remember that this has to be something specific. We, as supporters of survivors, need to make sure that it is signed. There is a document that is specific to initiating a formal complaint in these cases, and that it is signed by the survivor, because if that doesn't occur and the Title IX process would proceed through, that's an open window for a respondent to say, actually, none of this stands, the sanctions don't matter, none of this matters, none of this really happened because you never even started the actual complaint process off as you were supposed to. Remember that their Title IX coordinator is your central contact throughout. They're the one that have to receive the report. They're the one that has to receive the formal complaint. They're the one that you ask for supportive measures. They're the one who's charged with implementing the remedies and the sanctions at the end of the process. Not only do we need to know who that person is, but we need to have a direct line of communication with them from beginning to end. We need to warn survivors about informal resolution if that sounds good to them, if that sounds like something they're interested in. We do need to warn them that we can't exactly tell them right now what that might look like in individual institutions. It's going to be really institution specific, I think, and it's probably something that may even change over time at institutions, because a lot of institutions didn't really have this informal process before at all. And so they're kind of coming up with their own processes right now. And so when a survivor says, well, what is that going to look like if we do that? We need to ask the school to give us any information they do have or any expectations they do have, but we need to be upfront with survivors that none of us have sat through an informal resolution that has taken place after the new regulations. We need to prepare the survivor for the hearing. So respondents might have attorneys, and we need to prepare them for all of the things that we know to be true about respondents' attorneys, namely that they are hired by respondents to get a result for a respondent. So, be prepared for respondents to do or say things at the advice of their attorneys that may otherwise be unexpected to come from that respondent. While attorneys are not supposed to be involved directly in the proceedings other than for cross-examination, sometimes some schools allow attorneys to be slightly more involved than in others, and so we need to warn the the survivor about that. Again, about the cross-examination, and that it may be a trained attorney that is subjecting them to cross-examination if there is a hearing. That I said loss of evidence because it may be true that we have survivors who go through the time of finding and explaining pieces of evidence that they think really show something that the school should know. And the school might ultimately say, yeah, we're not going to consider that because it's not relevant. Or because of the cross-examination rules, if someone doesn't show up to the hearing, the decision makers can't consider their previous statement. So that can be a surprise and a letdown to survivors. So we need to give them that heads up. And again, the duration of the hearing's going to last longer because of this cross-examination process, because each individual question has to be deemed relevant by either all of or one of the decision makers. We'll see. And so there's going to be kind of this awkward pause between each question, and that's just going to make the whole thing last longer, probably. For the appeals process, again, keep in mind that even if the survivor gets the result that they want or that sanctions are imposed, those aren't going to actually take effect until after the appeal is finished completely. Again, these appeals may be more drawn out, probably only one round, and probably unlikely that more than those 3 grounds are given. And then as we look to OCR and beyond, for all the reasons we already talked, this higher standards are going to make it more difficult for a school to be found in violation of Title IX, and therefore for there be relief to be given to the survivor that they hope for. I also think as we look at OCR particularly, OCR is probably in the cases where they do determine that they are going to conduct an investigation, I anticipate that there's going to be a focus on trying to do an early resolution process rather than a full investigation of an institution. And so there's going to be probably pressure put on survivors to engage in this resolution process, which is kind of like a mediation negotiation, coming into an agreement with how the school will handle cases in the future. Maybe it is schools paying for medical bills or counseling bills that weren't already paid for, things like that, but probably not some real significant finding of fault on the institution's part. So I can see this being offered in a lot of cases, and so survivors should know that ahead of time. All right. We're here to help. We have coming to you some hard copies of some items. These practice points, similar to the ones you saw in this PowerPoint, we're going to give you a sheet of step-by-step guide in tackling these new regulations as they take effect. Also some key guidance, some more overall guidance of do's and don'ts in working with survivors throughout this new process, and you will be receiving OAESV's input in the form of a manual about the Title IX process in general and the impact of the new rules. All right, are there any questions for us?
Kendra, there was a question that was posed while you were talking a little bit ago that said, can you address what is meant by quote unquote respond when we give the draft report to complainants and respondents to review the draft report? What should we tell them to respond to? If you could clarify and give some examples.
Sure, good question. As with all other things, I will say it's going to vary. So that is one of those areas where schools are going to be able to probably say, some schools may put more guidelines into what that response should look like. But overall, I would say we can expect that to be a written response. So probably a written statement, and it's a chance for the, so for instance, if it's a chance for the complainant to, for the survivor to, number one, respond to things in the investigation report that they think are wrong or were misunderstood by the investigator. And this could be minor things like, you know, hey, investigator, you said that party A and D were with me when I walked back to my dorm room, but really it was party A and C, things like that. Or it can be, you know, in the investigation report, it looks like you think that I got back to the residence halls at 6:02 p.m., but what I really told you was 6:02 a.m. So kind of fixing some inconsistencies that can muddle up the statements later. And then also it's an opportunity to bring to the investigator's attention either inconsistencies or just false statements in evidence given either by the responding party or by witnesses. So for instance, if the respondent says, you know, when we got to my apartment, I gave her when we got to my apartment, she wore her red shirt and her blue shorts to bed. And if we know we have a picture of us that day at the respondent's apartment and we say, no, he gave me clothes to wear to bed, and why this would really be relevant, I don't know, but sometimes. And he gave me a t-shirt to wear and no pants, and here's a picture of me at his house at that time. We should be able to explain that in response to the investigation report and to even provide that picture as part of the response. So I think the latitude is pretty wide. I think we can expect to tell survivors that that's going to be a written response into any information that appears in that initial investigation preliminary report. But to also keep in mind that we're going to have to tell survivors that, remember, the other party's getting the same opportunity. So we can expect some pushback on their part, especially if that initial report seems to be suggesting that the investigator is leaning toward, you know, suggesting that a hearing should be held, that there might be responsibility. We can see probably what will happen is the respondent responding to that with information they think would sway the investigator the other way in the final investigation report.
So that is all the questions we have at the moment. So I just want to encourage everyone. We have some time we set aside specifically to open it up to answer any questions you might have, whether we can answer them immediately right now, or we can always get back with you individually about any questions. But really wanted to leave some time open if you had any questions or concerns or anything like that, to please share those. So if you want to write those in the question box, we can share those out so that one of us can look at addressing any questions you might have. Another question came in. What happens to a respondent's statement? Oh, hold on, we got a couple. My screen moved. What happens to a respondent's statement if they do not show up to the hearing? If the statement is not considered, if so, not sure what this looks like.
Yep. So that is unclear. It seems to suggest in the straight language of the rules that if a respondent either doesn't show up to the hearing or shows up but refuses to answer cross-examination questions, which is their right, that they would be treated like any other witness in the sense that their previous statements would not be considered by the decision makers. Now, that seems wholly problematic because, you know, the respondent is not forced to give those preliminary statements either. And so if they choose to do so, that should be considered by the decision maker. This is me saying this as if I'm advocating as a lawyer. So it is my hope that there will be a distinction made between witnesses and respondents there. But I think there is a chance that there's not, and that that will have to be fought out in OCR and in case law.
Great. In reference to the slide with free speech is not harassment, words alone are unlikely to be a violation or retaliation. We shouldn't, as advocates, be telling survivors this definitively, right? Would that be more appropriate guidance coming from an attorney?
Yeah, so what I mean by that is we should not say to survivors that's probably not actually sexual harassment. What I mean by that is knowing that to be true ourselves, we should ask these additional questions to try to help the survivor frame what happened. We know what happened to them was words. There was more of an impact. It affected them in various ways. What I think I meant by that is we need to be really specific in those complaints. Because the school's knee-jerk reaction is going to be to say that's not harassment. They were just expressing their free speech. So we really need to get to deepen in to show the school how it was offensive, how it was harmful, how it prevented the survivor from, their right to education and that sort of thing.
What happened to pre-existing cases that are still going through the process of Title IX investigation? How would that change?
So previously, always it has been the case that the rules that were in place when the Title IX case was launched remain in effect. So I would argue as an attorney that that should be true now. If a school is attempting to impose new regulations on a student who had already received clear notice of other processes that would be in place, the former processes, then a attorney should advocate for that on the survivor's behalf. It could be the case, though I don't know. I haven't really thought this through. I guess it could be the case that a survivor preferred the new regulations for some reason. But I think we need to be careful there. Probably shouldn't advocate for that because probably in most all cases, it's going to be true that the former regulations in place were going to be easier to understand and more familiar to the survivor. So we should be advocating if the school is not automatically doing that those should remain in place. And I think that should be fairly simple as long as it's already to the point in the process where the survivor has received a copy of those previous procedures as the ones that will be used by the school.
Great, thank you.
However, I would say that while the new regulations may not be used specifically by the school, I think we can begin to expect immediately that these overriding themes will affect the process, no matter which policy is it, which written policy is in place. So we're going to see probably a focus on away from punishment early on, and we're going to see a focus on protecting free speech and preventing bias, things like that.
Great. Do you recommend the written responses from the complainant and respondent be incorporated into the final report as proof that the responses were considered?
They probably will be. I would anticipate that what will happen is, so because there is this requirement that not only the response, that both parties be able to give responses, but they also be considered by the investigator before the final report. What I would anticipate happening is that there will be some additional language in the investigation report that says, this is what was stated, either one of two things. It will simply just give a summary of what was stated in the responses and also include a copy of those responses, or the investigator will take it a step further and say, having considered this information in the response, this affected this previous conclusion I had come to, or whatever. So there will be, I believe that those responses will be addressed at a minimum to acknowledge that they were considered. And so I would anticipate that we would see a copy of those when the final investigation comes out, although we're going to see a copy of those anyway, because both parties have a right to the other party's response.
As a campus advocate through our agency, not the university, in your opinion, should we plan more events to show that we are still there for survivors?
Absolutely. Absolutely, we need.
If you would like, Kendra.
Yeah, go ahead.
So as an advocate, I would definitely recommend doing that. As with these regs, I think what happened when there was guidance the last time is there's a lot of like misunderstanding, a lot of information flying around about who was reporting, who wasn't reporting, what the responsibilities were. And I would highly recommend that right now. Not only do we have these new regulations, but we're also in the midst of a pandemic. So with that, it's really important to get advocate voices, to get Rape Crisis Center, campus advocates, those supporters information out there. But I'd also say the same thing to universities too, right? To make sure that you're sharing as much as possible and be transparent, right? Make sure that you're showing that you're there, how to access you, for advocates in particular, what those resources are, what you can provide to them, because it's going to be kind of unclear, I think, about the roles right now too. As we've said for a couple of days, the term advisors is a misnomer if it's someone who's appointed by the university, if they're only asking the questions that are provided. So really outlining what the roles are, that you're there for them, what that looks like, is being as open and transparent about that as possible, and as many medias as you can, right? So social media, if campuses are coming back in person in the fall, if K through 12 is coming back in person in the fall, share out there. If you can do so, any in-person events, any flyers you can put out, social media, websites, right? Make sure all of that is updated, providing information and keeping that ongoing as much as you can. And also making sure to access those organizations or those groups that are historically not approached. So making sure that you're accessing every different various group that you can to make sure and ensure that you are there for them. Anything you want to add to that, Kendra?
No, thank you. But the answer is yes. Anyone we can reach and offer support, the sooner the better.
Along that same line, we had a question about providing contact information of how to get survivors linked with attorneys.
Yeah, we will provide that when we send out the additional materials on how to reach out to, so you can reach out to us, and we will look at the case, and if it's a case we can take on, we will try to find either a local panel attorney to take on that case, or the clinic. So yes, we will provide that information.
And as a reminder too, I don't know if you were on earlier or the prior webinars, but ODVN has a very similar panel to us as well. So we focus primarily on sexual violence. We also can do some stalking cases. ODVN also has a panel that can do a more domestic violence, dating violence. So we talk to each other, but just as a heads up for that, if you're seeing something come in that falls into a domestic or dating violence, and we can also share that information out as well, so you know the link to get to that information, so you can access that as well. Another question, because it's so important to get an attorney involved in cases from the very beginning, will OAESV/ODVN have the ability to help with this increase if the law application is approved, or is it more likely that survivors will have to pay for an attorney?
Our goal is not to have survivors paying for attorneys. We are increasing our outreach and training of panel attorneys, so there will be more attorneys around the state educated and willing to take these cases. So the hope is there is not the result is not that survivors are having to pay attorneys, but the reality is that the regulations have put this kind of ominous possibility on all of us, because when they said they would provide free advisors, they took the step of saying that person didn't have to be an attorney. In other words, schools don't have to provide free legal assistance, but we will do what we can, and we are reaching out to as many attorneys around the state as possible. So please continue to use the intake system.
Absolutely. I think we'll talk as well and share out how to make those requests, those applications. I know that there's probably some people on the line that probably have no idea what we're referring to. So that's our Legal Access Works application, and we will talk and get some information out about how to apply and what that looks like. So if you don't know what we're talking about, that is okay, and we will make sure and share that information out so that we can, everyone has the ability, particularly advocates, to make that application. The next question we had is, would a house that a fraternity or sorority rents off campus, where some of the members choose to live, but the house is not owned or controlled by the school, is it considered not in geography in accordance to the new regs?
Great question. The answer is I don't know. Arguably, however, the school would have control over that person that committed it if they are a student. And so that should be enough to make them fall into that umbrella of responsibility, but we will have to see how schools interpret it. You know, if they take that language strictly to say owned means owned. Remember though, Cleary still exists, and so I am hopeful that schools will still use that as guidance in defining those perimeters.
I will add to that, and I actually just pulled out the regs to see if I could specifically find the part in the regulations where it talks about it. They do talk about a location that's owned or controlled.
Owned, yeah.
But it doesn't talk about renting. So
right.
You would assume that controlled, that if you're renting, that would be controlled by. So if the organization, or if the institution recognize the organization, that is in reference to the regs do put that in there. The renting is a little bit different, but one can make the assumption. I think that's where it's a really good, really important to touch base and see how your institution is interpreting that language. Like I said, the way we would read it would maybe differ from how others would read it, but they do mention that in the regulations, talk about owned or controlled. What particular policy steps would you recommend that students encourage their Title IX offices to adopt this summer?
Trauma-informed training of everyone involved, and when everyone involved, I mean all of the Title IX staff involved. That is not specifically required in the new rules. While everyone is supposed to be trained in that and whatever that training is supposed to be available upon request for review. There's no specific requirements that the complexity of trauma and of the impact of sexual violence is something that those people need to be trained on. And so I think that's a good first step. Becca, I don't know if you have.
I would agree with that. I would really encourage that. And schools listen to students, right? They want to hear from the students what they want to do. I would also reach out to your local programs as well and get some of their expertise about different things that they're working on. But I think that would be a great idea to start. We've had another question. I am a Title IX coordinator. Can only advocates request advisors, or can coordinators use your services as well?
So,
so we have our Legal Access Works application process does have advocates submitting that application because we consider it a best practice for advocates and attorneys to work together. If you are in an area that does not have an advocate, so for example, there's still a couple of counties in Ohio that are not covered by rape crisis centers, then I would say reach out to us and we can hopefully connect you with an advocate that can do that work for that survivor. But we do have those applications coming in from advocates.
Yeah,
also, yeah, go ahead.
I was just going to say, so then the answer is yes. However, we would ask that the first step be that you connect that survivor with a local program, with a, like a community advocate, a rape crisis center, and then they will take it from there to connect them with an attorney. So if at all possible, that would be the first step we'd ask. But yes, we can take cases if a coordinator identifies a survivor without representation.
We've also had a comment that looks like ODVN is doing training for their Legal Access Works program on the 4th of June. So if you tune in there, you can learn how to apply for ODVN. And like I said, it's a very, very similar process. So typically, if you know how to apply to one, you know how to apply to the other one. So thank you to that person who shared that with us. Is there, I believe I've got all the questions at the moment, unless I've missed any. Are there any other questions, and or did that answer all the questions that we've asked that any of the other participants have?
And we know that probably questions will, for certain, questions will arise once we're kind of out there and have questions come in from survivors, or once we see some of the school's interpretations. So this is not your only opportunity. Please reach out to us for technical assistance anytime. That's what we're here for.
Kendra, who should they contact after the webinar?
You can contact me. Let me go back. There's my email address that's the best way to get a hold of me. And then I respond by email. We can set up a call or a video chat, or I can just respond quickly by email if it's a brief question, or if you just need materials, yeah, reach out.
I would also say if you forget or lose Kendra's contact information, if you just reach out to OAESV, generally they can get us your information. So I know that sometimes I will jot things down on Post-it notes, and then suddenly this Post-it note disappears. So reach out to OAESV, and they can reach back. They can get you to the right person. So just as a heads up with that. What training would you suggest for K-12 teachers, counselors, school resource officers besides trauma-informed care?
So the trauma-informed care, I think, is a large umbrella. Whoa, I would suggest, so along with that, kind of the maybe sexual violence in general and behaviors associated with sexual violence, particularly for K-12 of juveniles subject to sexual violence, and then of Title IX in general. So something like one of our trainings where we go over the regulations. They should be receiving that, obviously, as a requirement, but because we include kind of that survivor perspective or trauma-informed perspective in many of ours, we would suggest something like that for them.
Along with the training piece, I would encourage that training to be done regularly, right? So make sure that for new folks that are coming in, that you're doing it on a regular basis. And I know annual training, sometimes if you've done it a couple times, that can be exhausting and overwhelming and things like that. But we do really highly encourage regular training on it. We know from research that hearing and receiving training over and over again is the best way to have people understand it. Also because oftentimes people, they may not have received anything that year, right? And this may be, they may have gone a year or two without, having interacted that as far as they're aware with a report or a survivor has reported to them or something like that. So making sure they're doing that regular training on trauma and particularly in K through 12, how early childhood education, how that impacts and all those kind of various different things. So really kind of training on that on a regular basis in the variety of different ways. Also the patterns of sexual violence, things to look out for in terms of domestic violence, dating violence, stalking, all those kind of different things, right? And I would highly encourage you to reach out to your local programs to get that training. There's some great online training that can be done. There's books and webinars and podcasts and all those kind of things. So I'm a huge proponent of any training that you can do and have access to that. Next question is, are we able to get copies of all 3 PowerPoints from the 3 different trainings?
Yes, you will get copies of all of the PowerPoints and that additional material from us by email.
All right. Any other questions from any other participants? Will we get a video link from the last 3 webinars?
Becca, it's recorded, so.
It is recorded. I believe we were making it available on our website. So I don't know that we'll include the link in the email itself. Typically, we just try to include the PowerPoints, but online you should be able to access the recordings. We'll have those up online for you. Oh, another training thing, I knew that I was forgetting something, and anyone who has heard me talk before is probably gonna be like, how has she not talked about this? I would also encourage any kind of training on self-care. You can bring in, not only do I find that helpful to those individuals that are working with survivors, but it also helps them help the survivors themselves, right? So that they can share some self-care techniques, what to expect and things like that, so that they can take care of themselves and help with that vicarious or secondary trauma. And also assist a survivor who's working through that, so they can provide some examples about and both mirror, but also provide to the survivors what kind of self-care they can do, and what and how parents can help as well. So particularly in the K through 12 context, having some training on secondary trauma can be very, very impactful. Because usually with K through 12, you're going to be having a parent or a legal guardian involved in some form or fashion. So having that can be really helpful, or be able to provide their parent or legal guardian with information on that secondary trauma, and the trauma that their peers and or siblings might be experiencing as well. Looks like that's pretty much all the questions are coming in. I'm sure as soon as I say that something else will pop up. I would encourage all of you to, if you have questions, concerns, comments, or individual TAs that come up, please reach out to any of us here that you have listed on the screen, or to OAESV more generally. I would also encourage anyone to go through some anti-oppression training as well. I think it's really important that we acknowledge that and kind of look at the intersection there. So if you are looking for additional trainings, you could also look at that for your teachers and counselors and deans and chairs and employees or whoever you have. So that would all be a good training as well. But please reach out to us. We are here to help and support survivors and anyone, all of you as well, who are working in this field. So just please reach out, and I will. Kendra, is there anything you wanted to add?
No, I just want to say thank you to everyone again for sitting through all of that new information with us, as we have been processing it ourselves. And please do reach out in the future.
All right. Well, thank you all so much for joining us for 1, 2, or 3 of these webinars.
Thanks, everyone. Goodbye.